This is Business Talk, and I'm Norman Less. This program is dedicating to helping people in business do business better. We're going to be into a subject today that is very, very important, and the subject is protecting yourself. We're going to examine some of the pitfalls for people who are in business and for some who are going in business. And my guest today is David Lehv, who is an attorney who specializes in commercial and corporate law. And he is going to be very helpful to talk about some of the things that face us. And Dave, welcome to the program.
Thank you.
And I guess we should start by saying with all the problems, with all the pitfalls, with all the mind traps that are out there today, is it dangerous being in business?
Sure it is. I'm not sure that it's any more dangerous than it has been in times past. Economically, I think it is frightening when one thinks about major corporations that have substantial layoffs of their personnel or their workforce, or a county in California, which is supposed to be the richest, which is unable to meet its
But how does that affect someone in business, in a small business, which is primarily our audience? How does it affect the small business because of the things that have been happening in Orange County and certainly in the corporate world?
Well, the answer to that is I don't know, because that's the economic side of it. Yeah. What I was going to say is that legally, I'm not sure that it differs very much from what it was in times past, but it is more complex, is my impression. There's an overlay of additional laws and requirements and reporting that tends to make things much more confusing than they may have been in the past.
Well, let's go through some of these. Let's be very, very specific now. Let's talk about setting up a business. There's always the question, do you just open your doors and go into business? Do you go open your doors, pick a name, and go into business? What about the entity itself? What determines what sort of an entity? What are the alternatives, and what determines the entity?
Well, going into business itself presents you with a number of choices, and one of those choices, as you say, is what kind of business you're going to be in. A lot of that is dependent upon the tax consequences of what form you take. You can be any sort of business. You can be a partnership, you could be an individual proprietorship, you could be a limited partnership, a corporation that selects Subchapter S treatment. New York has a new entity called it's not new, nationally, we're probably one of the last states to have it, but as a new entity called the Limited Liability Company. Or you could be in that category, which is some other business form.
But you say tax considerations. Is that the main reason?
Primarily, it's tax considerations or liability, questions of whether you're going to be exposed personally to the claims of creditors or to those people who may be injured by the acts of your company.
So we know, of course, that before you set up anything, you should talk to an attorney, an accountant, and maybe insurance people, as we'll get into later on. But are there any specific guidelines on which is better for any type of business? I know you specialize in service businesses and advertising and marketing businesses. Is there any particular form that is better than another one? Is there a rule of thumb?
There's no rule of thumb. As I said before, there are choices, and each of these choices have their own merits and their own detriments. The tax consequences control this normally, and tax reasons is sort of a euphemism for it's too complicated for me to explain. The liability side of it, which is probably more exaggerated than necessary, because there are insurance arrangements for covered risks, and a prudent course of action should normally protect you from anticipated risks or those that would come up.
We're talking about risks. Are you talking about risks to the individual?
Well, risks to the individual's pocketbook, certainly. The corporation is a fictional entity that creates a barrier, theoretically, between your creditors or claimants and your personal property, so that when you establish a corporation as opposed to, shall we say, a partnership, you're insulated from almost all claims. There are claims that pierce the corporation.
So does that mean that everybody should establish a corporation?
No, I don't think so. But then we get into tax reasons, which is again. And a lot of it may do with the custom and usage in the industry as to what kind of businesses are doing the similar things that you do, and are they set up in this format? But basically, you can get protection, and most of the small businesses that one would establish, in small or medium-sized business to be in a service industry or other industry, would be a corporation for that very reason, to insulate themselves from or their own property from liability.
So it doesn't say, hey, I'm in business, I'm going to pick a name, print up some cards and some stationery, and I'm in business. Before you do that, there are things to think about, like something I just touched on, which is picking a name. It's not that simple, is it?
Well, it's not that simple, because if you do take the wrong name, you may infringe on somebody else's established name or even registered trademark. So it is prudent, of course, to go and conduct a search to find out if anybody else is operating in your line of business under that kind of name. Searches cost money. So
is that locally, or is that?
Well, locally, it would be worthwhile to look in the phone book, certainly.
Mm-hmm.
It would be worthwhile to check around to make sure that, or maybe the local Chamber of Commerce, to make sure that nobody selling what you are selling is using it under a similar name. But there are more extensive ways of doing that, and that is to commission a trademark search, which searches not only trademarks, but trade names, business names. They do it in the registration in Washington, and they do it in various states and locales, and they have this all set up.
Isn't it true, David, that in New York State you cannot do business under an assumed name without registering that name?
Yes, you're not supposed to do business in a state under an assumed name. The fact, however, that you are given that you are permitted to apply to do business under assumed name does not mean, however, that you are not infringing somebody else's use of that name in the state. They're different.
So they do not.
They won't authorize you if they know of the other business's name. But not all trademark rights are dependent upon registration, so that if somebody has, in fact, that name in use properly, and they may not be a corporation, they may not be registered with the state, or they may not have their partnership certificate registered, they still may be able to preclude you from using that name in your locale.
There are instances which I've read about. For example, if you open a restaurant and your name is McDonald and you call it McDonald's.
I would think that would be present a problem, and I promise you will hear from them, and quickly.
And there are some people who are capitalizing on Toys R Us and saying that mattresses are us or something else are us, and even that R Us becomes an infringement. At least it's something that's attacked. So you have to be very careful before you pick a name, and certainly be careful, as you've said, before you go to the expense of printing up any material. Because you may have to do it all over again. Okay, so you're in business and you're doing business, and you've got this wonderful idea of, instead of hiring employees, you're going to use one of these sources that provides people outside. Is there a problem with that?
Yes, thank you for asking. Of course, there are lots of problems with that. Not a problem with hiring people who are sourced from outside. That in and of itself is not a problem. But there are major issues now, particularly questions of tax law, which have to do with the qualification of your workforce, how you categorize people. If you are hiring people who are essentially employees and functioning as employees, but calling them freelancers or independent contractors, the likelihood you are not doing a bunch of things that you have to do with them, primarily withholding payroll taxes, paying FICA, paying the employer's share of FICA and collecting the employee's share of FICA, paying unemployment taxes and workman's compensation.
Define FICA for those who may not know what it is.
It's Social Security.
So, okay.
You have to have disability insurance under New York law, workman's compensation. But
if you're using a company that is providing all of that to people who are working for you and are not on your payroll, is that illegal?
It is not illegal to utilize somebody to provide those services, and those are very useful companies. And one of the benefits that those companies can provide, in addition to getting you qualified employees, is that they can establish that the collections of the withholding taxes and the FICA and all of this stuff is being done, because that's what they do. They make sure that these people who might otherwise be paid on what's called a Form 1099 are in fact having the withholdings made and making the payments. But as an employer, literally, you are required to ensure that these things are happening. And therefore, if the Internal Revenue Service is in a foul mood that day and comes in and takes a look, they can require you to make these payments and pay penalties for having failed to make these payments, notwithstanding that they've been paid elsewhere.
How do you protect yourself against this happening? Because you said if they're in a foul mood that day.
Well, one way to protect yourself is to ensure that the people that you are hiring, whether it be from one of these sources or whether it be just independent freelance people, are in fact what are considered to be independent contractors. Independent contractor is a term of art, which means the opposite of employee. It means that it is someone who is not theoretically under your direct supervision and control, who is in business for themselves, and who maintains an investment in their own business or separate entities. So an employee is sort of a quack test. If it walks like an employee and quacks like an employee, by God, it is an employee. And the Internal Revenue Service imposes a 20-factor test to determine whether someone is an employee or not. But ultimately, it's in here somewhere, as you know.
I want to get into the subject of employees, but first I do want to remind our audience that we're discussing the subject of protecting yourself when in your business, and that my guest today is David Lehv, who is an attorney with offices in New York and in the White Plains. What's the name of your firm? We should get that in there at this point.
Davis and Gilbert.
Davis, and you're a partner in that firm. To get into the subject of employees, in today's world, there are certain things that one must do in relationships with employees. Where do you start? What's the most important thing to do?
Well, there are reporting requirements that are fairly tedious, and I'm not sure you want to talk about them now.
I wasn't talking about reporting. I was talking more about understandings between you and your employees.
Well, probably for a smaller business where you are not engaging people on contract, where you don't hand people, executive employees, with contracts of fixed terms, the most important precaution that ought to be taken is to establish policies. Hopefully they will be included within some sort of personnel manual or employee handbook, but policies that set forth the philosophy of the company and the rules and regulations, I suppose, that apply to employees generally so that everyone knows where they stand. As a general proposition in New York, employees are called at will, which means they can be terminated, I'm sorry to say, for any or no reason except certain prohibited reasons, such as discrimination on the basis of their race or nationality or sex or age.
Yes.
That's right. But there are cases that suggest that where a corporation has policies that are in effect, the employees look upon these policies as though they were contracts with employees. And so if you're representing management, as I often do, what you want to do is make clear, write in whatever policies you have in bold print, that this is not a guarantee of employment, nor is it a contract. From the employee's side, they certainly have an interest in understanding what they're entitled to and would like to see what the company's policies are so they know if they're being treated justly and fairly through that.
Is this manual a complicated process? Is it something that runs hundreds of pages, or?
It can be for the largest companies, but even the smallest companies, it's worthwhile to have some outline of particular policies that insulate you from liability. One is what I just mentioned, is to make clear that although you perceive yourself to be a fair and reasonable employer, you are not inhibited in reducing your workforce if there is a problem, so that this is not a contract, you're not guaranteed employment. Another would be in the area of employment discrimination or sexual harassment. These are insidious claims and can be very, very difficult if unfairly brought. If they are meritorious, then shame on you. You sort of deserve what happens to you. But in my experience, there are many claims that are brought with very little substance to them. And when you think about how damaging they can be to a company or to the morale of a company or to the individuals who are accused, they're very hard to defend against. So that when you assert that someone is discriminating, how do you say, no, I'm not?
Well, discrimination is one thing, harassment is another one. We talk about, certainly we read about sexual harassment situations, certain things that you can do and cannot do. There's other types of harassment that that we hear about too. Is bad language, for example, considered to be harassment?
As a general proposition, the only harassment we are talking about is sexual harassment. Or I suppose it could relate to, it could be racial or any of the other prohibited discriminatory categories, but I'm sorry to say, and perhaps many of us have suffered from it in our own experience, that an abusive boss is not in and of itself something that you have the right to do anything about. In the areas where it is prohibited, foul language, for instance, which one would find offensive and create what's called a hostile work environment. There are, at least in the sexual harassment area, two forms of sexual harassment. One is called the quid pro quo, that is, favor me with your favors, or you will not get a raise, or conversely, you will get some sort of benefit from it. That's fairly overt and offensive enough, but the hostile environment circumstance is what occurs a lot, and that's where you're in an employment situation in which the management is abusive. You are subjected to circumstances that really are offensive to you, being theoretically a reasonable human being, and that is where bad language and attitudes and gestures and unwanted advances really are.
Now, is that all male to female,
No.
or is it male to male, female to female, female to male?
Yes,
it
to all of those questions.
It applies in all of those cases.
Many reverse situations.
We're talking about employees, and one of the toughest things to do, people tell me, is to fire somebody. And when you have to let someone go, we're talking about whether you must have a cause. You say in New York State that's not necessary?
Well, if you promise not to depict me as Simon Legree, I will tell you the law, which is no, it is not necessary. It is important, in all fairness, it is important, but there are businesses that can't make a go of it and have to release people unwantedly because, and they do not need cause to do that. What you want to avoid, however, is people being let go for reasons that are untoward, such as, again, discrimination or age.
But incompetence is...
incompetence is a perfectly valid reason for discharge. As a matter of fact, you don't need reason.
You don't need a reason.
No.
And if you do let someone go, and then a prospective employer will contact you and ask for references, are there things that you're permitted to say and things that you're not permitted to say?
Now, as a matter of fact, there's no, as far as I know, there's no prohibition against giving a recommendation. It is often advised, and lots of companies adopt policies to not give one, because if you think about what is or is not said on a recommendation, you invite criticism. So, for instance, it is one thing to discriminate against someone. It is another to retaliate for them making a claim. It often happens where someone makes a claim. It's not meritorious. They are dismissed from their employment, and thereafter, or actually my timing's off, but thereafter they make the claim, and then the company is asked for a reference, and they give what is genuinely a negative reference because the person was let go for incompetence. Well, you're inviting trouble because at that point the person who was let go said it was one thing to let me go, but when I asserted my rights, you then retaliated against me by trying to hurt me in my prospects for additional employment. So lots of companies will have policies that say we give name, rank, and serial number, and we do not encourage references. It's very difficult for someone leaving employment not to have the ability to get a reference. And these things are honored in the breach very often.
So what you're saying is that it's not illegal for someone to give a bad reference and say this person was incompetent.
No, but be careful. It could be libelous. I'm slanderous.
It could be... And therefore you could
I think what normally happens is that people don't give bad references. They limit what they can say. And so they say as much as they can about the person that is positive or neutral, and probably refuse or should, avoid saying things negative. And then there are questions of privilege. There may be circumstances in which someone is depending upon you for a good evaluation of this person. And either I think you have to say, I'm not prepared to give you a reference, or you have to decide that it is important enough to me to make sure that this person isn't misled by the prospective candidate. This is
I
very
have heard it said that when someone does ask, the safest thing to do is to just confirm the time of the employment and the position that the person
It's certainly
held.
the safest, but you may be doing a disservice to good people, and you may, I don't believe that employers generally enjoy or look forward to the idea of letting people go, and they feel badly enough that they have to do it. And those are the people who are most likely to want to enhance their opportunity to get employment elsewhere. They should not overstate, certainly, the person's talents, but they should be able to speak openly with somebody else. And unfortunately, if they do speak openly, it may result in problems for them.
We're in this whole subject of protection, and we're talking about all of these negative things, and we don't want to indicate to everybody that being in business is a place that's loaded with minefields, and you shouldn't go into business. On the other hand, when one is getting ready to go in business, whether in a partnership or any relationships to others, it is always best, I'm told, to have agreements in writing, not for today, but just for the possibility that there may be a day when it's necessary. Is that a good rule?
Oh, it's a great rule. I apologize for the hackneyed metaphor, but a partnership or going into business with a bunch of other shareholders who are principals in this business is a marriage. And a premarital agreement is this partnership or shareholders agreement. And it's somewhat dicey. It's difficult to get over these issues, but it's critical that you avoid problems by having this in place. What's very interesting when you discuss these agreements with people is the dynamic of what goes on, because you have 3 or 4 partners sitting around the table, all of whom are thinking about what's best for them in particular circumstances, and then realizing that the reciprocal to what is best for them is that their partner, who's going to have exactly the same rights, and how would they feel about it if he exercised it. And then there is a third person in that room, and that is the corporation. I've found that the best approach is to look at it from the interest of the corporation at large, assuming that you want this to be a continuing entity, and say, what is the impact going to be on the corporation, and hence the rest of us, in the event that somebody departs.
One of the things that people should think about when they are joining with others in a business is what happens if one of them dies or gets seriously ill. And there should be something that spells that out, shouldn't there?
Well, that's the partnership agreement. The partnership agreement really controls 2 aspects. One is the governance of the entity going forward, how it's going to be run, what are your agreements, who's going to be what officer, and what is the weight of their particular vote. The second is the disposition of one's interests in what are often referred to as sale events, and that would be death, disability, insolvency or bankruptcy of a partner is one of the...
And to cover it with some insurance in terms of this happening, buy-sell agreements, terms on that?
That funds the... most agreements have a provision that say that if you leave, let's say, if your employment is foreshortened because of your death, the company will have to buy out your interest. That prevents your interest from being passed through to the estate of the deceased, but at the same time, the company takes out insurance to support that, because you never know when that's going to happen. There are other circumstances, however, when people leave a company where you might want to have a different arrangement. For instance, if they voluntarily walk away, within a finite period of time, you may want to discourage that and give them a lesser purchase price, or if they're discharged for cause. And probably the most touchy aspect of it is whether or not they are going to agree to refrain from soliciting or servicing your company's business upon their departure, on the assumption that their departure will have an impact.
All of these considerations have to be made in the most glorious times, sort of the honeymoon, when everybody loves everybody and everybody is very optimistic that all is going to work out. But you must think in terms of negative situations, when there's a disagreement, when business is bad, when something is going to go wrong.
It makes lawyers very unpopular, because people who are imbued with the sense of their entrepreneurial excitement, look at you and say, why are you doing this? Why are you laying this out? It's you're selling me life insurance and I'm very healthy. that's the nature of the experience. I think that if you have one of these agreements and you never use it, you are very lucky. And if you have one of these agreements and you are compelled to use it, you're very lucky.
Yes,
So,
either way, it's a
right.
win-win situation as
Right.
far as it's concerned. Now, I know you specialize in advertising and marketing, and are there special considerations? We don't have a lot of time to go into the details of that, but one of the things that I know is important is who's responsible in case of some misrepresentation. Is the client responsible, or is the agency responsible?
Well, actually, there's collective responsibility. The Federal Trade Commission, which monitors this and governs it on a national level, has a rule against unfair and deceptive acts and practices in commerce, and they have stated that advertising agencies, or the ones, are independently responsible for false advertising.
They don't have to know that the information that's been provided to them is false?
I'm sorry, Norman. They have to have a reasonable basis for making the claims that are made. So the failure to get a reasonable basis to have that is, I would say, perceived as negligent. It's irresponsible.
So you haven't found that the client's product really works?
You don't have a basis for believing that the claim that you are making for the client's product is true. Mm-hmm. Now, clients bear ultimate responsibility, and there are often agreements between agencies and clients which dispense or allocate responsibility and have indemnities one to the other. Agencies are responsible for certain areas of their operations that clients rely upon them for. Clients clearly have the ultimate say in what is said about their product.
So what you said, to sum up, is be careful. Talk to a lawyer,
Right.
accountant, talk to an insurance man, get the experts for your help. And it's great to be in business because the potential is great,
Right.
but be careful. And I thank you very much for joining us today and enlightening us on this subject. My guest today has been David Lehv, an attorney, and we have been discussing the problems, pitfalls, dangers of being in business, and the rule is protect yourself. The name of this program is Business Talk, and I'm Norman Liss, and until next time at this time, good luck.